Hello, welcome to today's webcast. I'm Bruce Carton, the editor of Securities Docket, and I'll be hosting today's webcast, which will be a conversation with Nick Morgan and Russ Ryan. Now, I wanted to call the webcast something provocative, like why two former SEC enforcement lawyers want to burn it all down. But these guys were not on board with that. They told me that's not what they're trying to do. What they did agree to call it is, and the reason is they're both working on bringing impact litigation against SEC overreach. So we'll find out what they mean by that and what the difference is, frankly, in that conversation. Before we hear from Nick and Russ, let me quickly just run through a couple quick things. First, we invite your questions. We welcome your questions. They're anonymous, so don't hesitate to ask any question you may have. You just click on the questions box and type it in, and I'll try to weave it into the discussion during the webcast. On the attachments tab at the top of the player, you can get the full bios for Russ and Nick, and some information about their organizations, information about Russ's column, Nick's YouTube channel, just a little bit extra information there. So let's get started. Let me start by introducing Russ Ryan. Russ Ryan is Senior Litigation Counsel at the New Civil Liberties Alliance, or the NCLA. The NCLA, on their website at least, says their mission is to be a nonpartisan, nonprofit civil rights group founded to protect constitutional freedoms from violations by the administrative state and to tame the unlawful power of state and federal agencies and to foster a new civil liberties movement. Russ has done other things in his career. Russ was a partner for a long time at King & Spalding. He was senior vice president and deputy chief of enforcement at FINRA for about 4 years. And when I met Russ was when he was assistant director in the SEC's Division of Enforcement for about 10 years. Russ is also a prolific writer and a thought leader in the securities enforcement in the SEC space. He, for many years, has written op-eds that have been published in the Wall Street Journal and the Post and Bloomberg. And he currently has a column on LinkedIn, which there's a link to it in the attachments, called On Second Thought, Unconventional Perspectives on Securities Enforcement. Russ, it's great to see you. Thanks so much for joining me.
Thanks, Bruce. Thanks for that introduction.
Absolutely.
Looking forward to the conversation.
With Russ today is Nick Morgan. Nick is the president and founder of Investor Choice Advocates Network, or ICANN, as he sometimes calls it. ICANN is a nonprofit public interest litigation organization dedicated to breaking down barriers to entry to capital markets and pushing back against overreach by the SEC. There's that phrase again. So that is what Nick is currently doing now. Formerly, he was a partner at Paul Hastings, at his own firm, Zakara Morgan, and at DLA Piper back in the day. But Nick also was with the SEC in the enforcement division. He was senior trial counsel there, and we'll talk about that. I think it's interesting on Nick's LinkedIn, he is a pro bono SEC enforcement defense trial lawyer. I think he's the only one of those in the world. I've never heard that before. I Googled it. There are 2 hits, and they're both from Nick. So I think that is your job title alone, Nick.
I'm not sure that's a good thing, Bruce.
I don't know. Maybe there'll be a second person following your footsteps. Nick also has a great video series on YouTube called SEC Roundup. Looks like they're up to at least episode 62. I encourage you to check that out. Both of these guys in their private sector days were real rock stars in the enforcement bar. They both were in Securities Docket's Enforcement 40 at different times. So you can see in 2017, 2020, Nick was in the most recent one we put out. In 2013, in the very first one we put out, Russ was in it before he went over to FINRA. So terrific lawyers all around who are now doing something really unusual and unique. So let's talk to them a bit about this. Let's start with you, Russ. So, NCLA focusing on securities regulation and enforcement. I'm sure they do other things, but what constitutional freedoms are being violated by the administrative state, and why does NCLA believe it needs to be tamed?
Well, writ large, the administrative state is really one of the least accountable levers of government, which nowadays dominates everyone's life. There's a federal agency regulating everything from when you get up in the morning to when you go to sleep at night. And we pursue a range of constitutional objections to what's going on with the administrative state, starting with administrators issuing rules or taking other types of coercive action that Congress has never authorized them to do. Perfect example of that is some of my colleagues filed, I guess just last week, a case challenging the Consolidated Audit Trail, or CAT. And one of the key claims in that complaint is that Congress has never empowered the SEC, or for that matter, any other regulator, to collect this vast amount of personal data from every investor for every trade they ever make in their entire life. So that's one thing.
Yeah.
In recent years, we've been focusing a lot on the adjudicative systems of federal agencies, and in particular the SEC. We were active in the case with Ray Lucia. We're active in the Jarkissi case. A lot of times we're amicus. We were lead counsel for Michelle Cochran, whose case was decided a year ago, which basically said, if you have an objection to the structural constitutionality of an adjudicative system that you've been brought into, you don't have to go through the whole process before you can get a court to rule on whether the process is constitutional or not. You can go straight to a federal district court. And the amazing thing about the Cochran case was that, and my colleague Peggy Little has really been the tip of the spear on this. She was facing basically a unanimity among the circuits. There were like 5 or 6 federal circuits that had ruled that you did have to go through the entire administrative process before you could ever get an Article III judge to rule on it, which in hindsight just seems crazy. Peggy was able to convince the Fifth Circuit to buck that trend. And so the SEC ended up seeking certiorari on it, and our client prevailed, and the rest is kind of history. The SEC promptly dismissed all of its pending administrative adjudications, thus mooting out both our client's case and anybody else who was prepared to challenge the system. So I'll stop there, but there's a few examples. But and we're not focused just on the SEC by any means.
I know.
Yeah,
Nick,
all comers basically.
When you and ICANN refer to bringing impact litigation against SEC overreach, what kind of overreach are you referring to? What are you looking at, and what are you focused on?
Yeah, so let me, before I do that, just respond to some of the things you mentioned, Russ. So first of all, I'm sitting there practicing as an SEC defense lawyer at Paul Hastings at the time. And we had a client who was similarly situated to Michelle Cochran in Texas, an accountant facing potential administrative proceedings. And so I asked an associate to research, hey, if we want to go to federal court and challenge some of this stuff, can we do that? Is that a thing? And he came across Peggy Little's appeal at the time to the Fifth Circuit. And I thought, this is amazing. And we talked to Peggy and ended up filing an amicus brief. And at the time, that was this was before ICANN was founded. But I was so impressed with the work that NCLA had done in that case from a practitioner's perspective of someone who's representing people in these cases and understanding that the process is completely unfair to the respondents in those cases. And so that was a formative issue. And this sort of gets to your question, Bruce, about what are the issues. So I think there is a significant overlap with the things that Russ just described. But that first amicus brief in support of NCLA's appeal to the Fifth Circuit and then Supreme Court on the Michelle Cochran case was a formative issue. And then we did a series of those amicus briefs and created ICANN. But before I created ICANN, one of the first people I called was Russ to see, because I've been reading Russ's columns for a long time, and he always raises interesting issues from a perspective I agree with. And so I wanted to get his thoughts on whether it would be just bananas to start a nonprofit from scratch to try and do these sorts of things. And although any errors are my own, Russ was very supportive.
What year was it that you started it?
Well, we incorporated it in the last couple of days of 2021. We didn't actually get going until middle of 2022. And I was doing it as sort of a side project, on an all volunteer basis while at Paul Hastings, and then went full time this year. So I think to answer your question, Bruce, the kinds of cases we're looking at. So one of the phenomenon that anybody who's been defending people in SEC cases for any amount of time will see is that it's expensive. It's very resource intensive, and so we've had a number of clients ask if we would take on their matter at a big law firm on a pro bono basis, and we did do that from time to time. But big law firms are in the business of making money, and they're very good at it. And it's hard to go back to your firm multiple times to say, "Hey, here's another person who's looking for pro bono representation." And so it's one of our focuses is, and it's still early days for us. We're still relatively new, but is to represent individuals who can't afford counsel specifically in potentially precedent-setting cases.
So how does the world's only pro bono SEC enforcement lawyer keep the lights on at ICANN? How does that work? Do you work with partner law firms? You have donors? You have both? Like how does that work?
Yeah, well, first start with a shoestring budget and very low overhead. Yes, we do rely. It's a 501c3, as I think NCLA is, and so we do rely on donors. But we're also fortunate enough to have pro bono partners, collaborators at big law firms. So in our cases, in each one of them, someone at a big law firm has gone to bat.
So you can kind of spread it out. Like let's say you have 10 matters you need help with. One firm doesn't get hit over and over. You can sprinkle it, and maybe they can take one case on.
Exactly.
Yeah.
Exactly. So 3 of our current partners, Baker McKenzie, Paul Hastings for obvious reasons, and Jenner and Block, and they go to their firms and say, "Is this something we can help with?" And we try to present sympathetic cases that make good pro bono type cases for big law firms.
Hey, I remember when Nick did reach out to me, and I was really kind of jealous. I was still at my firm at the time, but I had been thinking along the same lines for several years that there's just this real need for someone who knows what they're doing in this space to be able to help people, particularly individuals who aren't all that well off, to basically not get steamrolled. I mean, if you go into one of these things pro bono and try to represent yourself, you're almost certainly going to get steamrolled. And as Nick said, a lot of us who know this stuff inside and out are at big firms, and the average person couldn't conceivably afford to pay a firm like the ones we were at. And it used to just break my heart to have to tell these people, we can't help you. But Nick had the energy and the ability to do it. I personally just don't think I could have pulled it off.
But you
never really got beyond.
You did end up somewhere similar. Like, so how does NCLA fund this operation? Different operation. It sounds a lot much bigger, but same type of thing where, who's how do you guys keep your funding, and do you rely on financial support or volunteers? How does that work?
Yeah, we definitely rely on donations from people who support our cause. And obviously, if anybody is out there who wants to support us or has clients that want to, certainly get in touch with me offline. I can put you in touch with people. I have no role in the fundraising here. I just know that we have a lot of donors, and we appreciate every single one of them, both big and small. But that's how we generally keep the lights on here.
All right. Well, I wanted to see how you both got to the point that you're at, and let's just like go back as an exercise to like say 2003. Okay. So Russ, you were a senior official in the SEC Enforcement Division in DC, and Nick, you were a senior trial counsel in the LA in the Enforcement Division Trial Unit. Russ, you were leading and investigating cases. Nick, you're bringing cases and litigating cases. Were either of you at the time thinking like, this is not right, this is overreach, this is unconstitutional? Like, when did that switch flip for both of you?
Russ, you want that one?
Yeah. Well, I'll go back even further. I was in the enforcement division from, I guess, 1994 through 2004. And back then, for a number of reasons, I'll be perfectly candid, these issues never even occurred to me. I mean, every now and then you'd have, there were a handful of practitioners out there who might raise interesting legal or constitutional issues, from time to time. People like Art Matthews and Frank Rosano, maybe Harvey Pitt. But back then, they were representing clients like Nick and I would later in our careers. Very few of those clients want to pay money to throw Hail Mary passes. They just want to get the matter over with, settle it, and move on. So my general recollection being on the staff back then was, we never even thought about these things unless somebody affirmatively raised them with us. And in general, we knew that if we just basically, not exactly ignored it, but just pushed back, eventually people were going to settle anyway, and the issue would go away. I think another factor was back then, the SEC enforcement program was, relatively speaking, sort of modest. Penalties were not a foregone conclusion, and even when there were penalties, they were pretty modest. Then, when you got to maybe 10, 15 years ago, it became more of a prosecutor's office, almost like they wanted to model it on a U.S. attorney's office and make it look and feel like a criminal prosecution, maybe at the JV level. But there was no question that the whole mindset seemed to have turned in a very dangerous direction, where you had civil regulators punishing people with, very substantial punishments, and having to prove it only, by preponderance of the evidence, with no real meaningful Fifth Amendment privilege to rely on, things like that. I think it was around, maybe 10 years ago, where I was already in the defense bar, but things were, starting to percolate, and my whole mindset started to develop, where every time the SEC announced some new initiative, you would say, wait a minute, where do they get the power to do that? And doesn't that make this like a criminal prosecution, where all kinds of constitutional rights seem to be getting trampled on? And one thing just led to another. And eventually, I think that's what got me to leave my law firm and come here, was that I found myself thinking about these things more and more, looking for cases to get involved in, to try to push these things, writing more, and just thinking, boy, that would be a lot of fun to focus full time on these bigger issues. And instead of sort of looking through reams of emails and documents and just trying to get the best settlement for my client, I'd rather actually fight something on principle and go to a place where they have and find clients who are willing to do that. So that's how I kind of turned it around.
I think my evolution has had some parallels, but slightly different. So the practice in the trial unit in LA at the time, the early 2000s, we brought a lot of Ponzi scheme cases where there wasn't a lot of legal uncertainty. There were securities involved. There was a pretty clear fraud. And most of the Ponzi scheme cases were steal the money type cases. So I felt pretty good about going after the Ponzi schemers on, fraud cases, lots of victims. And I think that's something the SEC should be doing. But then I started getting involved in cases where there was a lot less certainty around the legal issues, sometimes around the factual issues. And I do remember working on one mutual fund market timing case where I just really wondered, what are we doing here? It was very much a post hoc, after the fact, constructed legal theory, and it didn't sit well with me. And so sort of from that point on, I started wondering whether there was always the SEC had the right mission. So I'm not in favor of burning the SEC down by any means, Bruce, to use your phrase. I think they have a good role, properly understood, but too often now it seems like they're straying out, and that becomes much more obvious when you start defending people, because there are, of course, lots of investigations that don't end up as litigations where the SEC spends years and lots of resources going nowhere, pursuing theories that, in my view, don't have any legs. And so, anyway, it's you see a lot more things on the defense side, at least than I saw on the SEC side.
I'm curious how you guys are received by the people that you either worked with or who at the SEC. Maybe some of them are still there. Are you, you're very outspoken in your criticism. Maybe a little more Russ than you, Nick. I mean, but maybe not. I don't know. Russ got his column. He's, the spectacular implosion of the SEC's adjudication system or the SEC penalty racket. It's a series of uppercuts and body blows. I don't know how many of them land, but Russ is, and you've got your YouTube channel, you got your ticker tape newsletter that I got today, by the way. And as it says in the beginning, it's a packed with stories about real people who have been ensnared by the SEC's predatory regulation through litigation approach. So, what are you, the outcast from the fraternity, or do people still treat you the same as they did before?
Well, I hope that. So I think we don't engage in any ad hominem personal attacks on any person. These are policy issues that, and I know I felt this when I was at the SEC. You are, for the most part, told this is, you're going to pursue things in this way. So I haven't encountered any animosity from people I worked with in the past or who I didn't work with, but I'm interacting with now. And I think it's, the criticisms, while pointed, are meant to be done with respect and to course correct. This is meant to say, hey, SEC, you're going off piste here. Get back to doing the core mission. So I haven't encountered any animosity.
Yeah, I'd say the same thing, Bruce.
That's good.
Although it might appear to you and others that I'm throwing, body blows and uppercuts and so forth, you'd be amazed how much time I spend self-editing to tone things down. And like Nick said, I don't think I've ever come anywhere close to an ad hominem against any individual. In fact, I rarely name people by name other than maybe the chair or the director of enforcement or something like. Even then, I tend not to I use their title. And, if I'm writing an op-ed for another publication, they sometimes sort of force you to use the person's name. But usually it's only if it's a very senior person who at least some people would recognize, things like that. For the most part, still many of my best friends are still at the commission or are alumni. I would say, in fact, most of my best friends have worked there or still work there. And I think anyone who knows me knows that I'm not trying to be mean-spirited or destructive, but maybe I'm.
Yeah, I would agree.
Story, but I think I'm trying to be constructive.
I would agree with that. Even with everything in your columns, and everything, like I would agree with the way you just put it. I think the difference is, like, when you're at King and Spalding or you're at Paul Hastings, you're defending and you're being zealous in your defense, but you're playing the same game as you were playing on the other side. You're just on the other side. I feel like you guys are kind of trying to change the game. Like, that's not even constitutional. You can't even do that in the first place, rather than like going to the, before the ALJ and seeing if you can win. You're just trying to change the game, in my opinion.
Yeah, I think that's fair. I mean, and at least in my law firm, I was never on offense. I mean, it was a game where the entire, 60 minutes you were playing defense, and you just wanted to be the best goalie around. And if the final score was 0-0, you took a bow and you went home pretty happy that night. So now we've got a lot more freedom, at least at NCLA, is to go on offense a little bit and file lawsuits on behalf of mostly individuals or small companies who really just they've gotten to the end of, they got nothing to lose at this point. They certainly can't afford a lawyer. And so they come to us, and if we think we have a good constitutional argument against some rule of the game or the playing field or what have you, we're going to do it. And, the Supreme Court has repeatedly said that some of the most important separation of powers cases are brought by individuals against the government, and we can't rely on our elected representatives to fight for their turf anymore. The institutions just don't do that anymore. The way you get precedential separation of powers and other structural constitutional fixes is by finding individuals who are willing to fight, and they either put up a defense when they're getting pursued by the government, or they take it on offense and they try to stop the government from doing what they're doing. And just going back to what we were talking about before, that the opportunities to do that at a big law firm are few and far between.
I would say the SEC, in a sense, does us a favor in a way, because the individuals we tend to represent, if the SEC prevails, these people are going to be financially ruined. They're going to be kicked out of their profession. And so they've got nothing left to lose. So, to use your phrase, Russ, to make a Hail Mary argument, I mean, they're in favor of making any argument because they're in such a desperate position. And that's why I say the SEC sort of does us a favor, that we're sort of liberated to make these arguments, because the alternative is financial and professional ruin. So it's under those circumstances where clients are all in favor of making some of these larger arguments that we just would never have brought in a situation where the client's really interested in getting the matter settled, putting it behind them, and going on with their life, which may involve interactions with the SEC in a lot of circumstances.
I want to get into some of the cases you guys are working on, but real quickly, I'm curious, Nick, is ICANN like a fledgling NCLA, or does it differ in its goals and mission that it will be 10 years from now?
So if I were to draw a Venn diagram, I think there's overlap, but I think our focus is a little different. As Russ said, NCLA has a much broader perspective. At the moment, we don't have the luxury of having a broader perspective, so we're staying pretty focused on SEC and maybe going out a little bit from that.
But within the SEC, is it identical, or do you have different?
Yeah, I mean, I don't know that it's identical, but every time I see an SEC case Russ is involved in, or one of his colleagues like Peggy Little's involved in, I think, I wish we had done that. This case that Russ mentioned about the Consolidated Audit Trail, it's a blockbuster of a case, and I think there is significant overlap there in sort of what we view as the problems that need to be corrected.
Russ, your most recent column, which is actually what made me think that I should get you guys together, was about the SEC and follow-on actions and the problems you saw with that. And Nick, I believe you were or are involved in a case on this point, the PacWest case. Could you talk about that case?
Yeah, I read Russ's column too. I thought, Russ, we've got a case. One of our clients, a gentleman named Eric Cannon, has been he's been a pro bono client for years at Paul Hastings, and now he's an ICANN client. He has been fighting in federal district court a case brought against him and a couple of other people. The SEC never alleged fraud against him, never alleged investor harm against him. It was a pure Section 5 registration case, turning on whether the instrument that was being sold, it's a fractionalized life settlement, was a security or not under Howey. 30 years ago, the DC Circuit said those instruments are not securities under Howey. I don't think any of us has uttered the phrase regulation by enforcement yet, so I'll break the ice and bring it up. But the SEC has the luxury of, that's what the DC Circuit said 30 years ago. Well, we can just keep trying to get a different answer by bringing these cases in other jurisdictions. So this case is in the Central District of California. Our Eric gets sued in federal court. The federal court judge agreed with the SEC that this instrument is a security, despite the DC Circuit ruling on summary judgment. That case is on appeal. So Russ's column was about follow-on administrative proceedings. So I'm sure your audience, Bruce, will already know what that is. But basically, when a judgment has been entered, or if other things happen, not relevant to this case, the SEC has the ability to bring a follow-on administrative proceeding to seek to impose certain types of professional bars. In this case, it would be a bar relating to Eric's involvement in the securities brokerage industry. The SEC's got a pretty easy bar as far as what they have to establish, that the judgment was entered in the federal court and that it's in the public interest to impose some kind of administrative remedy. So it's a process. It's not super fair. It's a flavor of administrative proceedings in general. So if they assign an ALJ, which has not yet happened, but if they assign an ALJ, there are other problems with ALJs that are currently being considered in the Jarkissi case Russ mentioned in the Supreme Court. So ALJs may or may not be constitutional. If we have a hearing on this matter, the appeal will be to the commission itself. So there are a lot of problems, and certainly from the perspective of someone like our client who's been fighting over this issue since 2015, it's just a long, arduous battle that, it's resource intensive. And again, not a lot of defendants, respondents would do it. And they certainly would be hard pressed to afford counsel over that period of time.
Russ, I know follow-on actions is fresh in your mind. Anything you want to add?
No, other than, it's just one of those things that the light bulb went off, just within the past year in connection with clients like Nick's who, were sued by the SEC for years. Contentious litigation, the SEC and its staff over the course of that contentious litigation obviously come to opinions about the defendant they've been pursuing for all these years have gone on record publicly, branding them as fraudsters or just lawbreakers. In Nick's case, I guess it's not a fraud case. But then they turn around and they magically sit as the judges in a follow-on case involving the same conduct. It's just so obviously biased. You could never go before a federal judge who had just sued you involving the same facts that the case before the judge is going to determine. I mean, of course they've made up their mind. They've filed numerous pleadings with a federal judge, and if they change their mind in the follow-on when they're deciding it, they risk getting sanctioned by the judge for filing false pleadings during the litigation. It's just, to me, I don't know how it didn't occur to me until just the past year that this brings the unfairness of administrative adjudication to a completely surreal level. I mean, it's just unthinkable when if you really boil it down to what's going on. And of course, it's only a small fraction of follow-ons. It's only the follow-ons that are based on a previous case where the SEC was the prosecutor. If you're criminally convicted and the SEC does a follow-on, this issue is not there. Or if a state regulator bars you and the follow-on is based on the state regulator's case, you've got all the usual problems with administrative adjudication, many of which are at issue in jarcossy, but you don't have this obvious self-interested bias on the part of your adjudicator, who in some cases, like Nick's maybe, they're contemporaneously still in litigation against you because they're defending the judgment on appeal. And so the SEC commissioners are simultaneously your nemesis in litigation and the judges of an precisely overlapping case in their own in-house forum. And I hope Nick and his client can prevail on that issue. And stay tuned. I may have my own, people up who are ready to make that challenge too.
Russ, I wanted to ask you, so, you and NCLA spend a lot of time challenging SEC on a big picture legal and constitutional issues. This question's for Nick as well, but given your experience with the NCLA, do you have any advice or guidance to defense counsel who may be dealing with these issues in their own cases? Any best practices or strategies to share to kind of help the cause?
Yeah, just stay aware of some of the big picture issues that are out there. I remember for most of my time in private practice, I thought I was, looking at all the issues, but I wasn't thinking that broadly. I was thinking more, all right, what are the facts that help my client? Is there maybe some wiggle room in the regulation where we can argue that it doesn't fit within it or not? I was, until later in my career, I wasn't really thinking about, can we raise burden of proof as a constitutional argument here or something like that? But, when you do think of arguments like that, even if you think they're Hail Marys, if they're not frivolous, at least raise them and preserve them, which really doesn't take a whole lot of time and effort. You don't need to spend 30 pages briefing something that's going to be a sure loser, especially in a district court. But I'd go further than that. I mean, I'm always willing to talk to people who are defending administrative action, particularly the SEC and its nearby regulators. And I'm happy to just talk things through and maybe put a bug in their ear on something. For example, I think everyone who gets sued by the SEC, especially if it's a fraud case seeking penalties, should at least be raising the question of burden of proof. There's no reason why the SEC should get away with the threadbare preponderance of evidence burden of proof when they're charging a private citizen with fraud. It's effectively a criminal case, but at a minimum, the burden of proof should be clear and convincing if they're charging you with fraud and seeking $1 million in penalties and things like that. I'd go further and say they should probably have to prove it beyond a reasonable doubt. But nobody, as far as I know, nobody ever raises and preserves that issue. And so you get to appeal, and then, you come to someone like Nick and me, and it's too late to raise it at that point. You've essentially waived it. And so I would encourage people to just call me or someone like Nick and just talk about the case. And, I'm sure I'll come up with something. You might think it's a frivolous argument, but there's almost always something you can raise and preserve so that if and when you get to an appellate court, or even more so if you're filing a cert petition, you've got a juicy, big picture constitutional argument that they're going to care about. They're not going to care about whether your client acted with scienter or not, or whether some obscure regulation covers this particular type of conduct. It's just so hard to get higher level courts to really get interested in those things. They will if they have to, but like at the Supreme Court level, that's just not the type of thing that you'll ever get cert on. You may get cert on an issue like I've been saying, are these criminal cases? And if so, should there be a higher burden of proof? Should the government not be able to draw any adverse inferences if you assert the Fifth Amendment? Things like that. Those are all unsettled issues, in my opinion. Another one is summary judgment. I think it's pretty well settled that in mill run civil cases, summary judgment does not deprive people of their Seventh Amendment right. I won't go into all the rationale of that, but I'm not aware of whether there's ever been a government enforcement action where a court has said, oh, even if it's a government enforcement action seeking penalties in a fraud case, summary judgment does not deprive the defendant of a Seventh Amendment right, or I would say Sixth Amendment, because, as I said, I think these are effectively criminal cases. But just think about the big picture. Start every time with what is the legal basis for them to be doing this to my client, and don't just if there's a few district court opinions that have said so what? Preserve it anyway. And if you're going to be going up on appeal, you're eventually going to get to a place where it's an unsettled issue. And I can't encourage it more to think these things through and at least preserve them, raise them as affirmative defenses, at least put a couple of paragraphs in your briefing about it. And I would say even if the law in your circuit is dead against you, you still raise it and you say, I realize I'm not going to win at this level because you're bound by circuit precedent, but I'm raising it and I'm preserving it. And that's really all you need to do in those circumstances.
I think a related point maybe, and maybe this is just restating what you just said, Russ, is don't be put off by the idea that, oh, this is the way it's always been done. Of course, the SEC has the authority to do X, Y, Z. I mean, if we look at the number of issues where that sort of thinking ultimately failed at the Supreme Court, it's getting to be a pretty long list. I mean, when I was practicing at the SEC, the idea that there was no statute of limitations that applied to our pursuit of penalties and disgorgement and whatever other relief, well, of course, we don't have a statute of limitations. That's just like And the Supreme Court said, well, wait a minute. And the same thing, I remember when we were doing our amicus brief on the Michelle Cochran case, we did throw in there a Seventh Amendment jury right argument. And when I shopped that idea around, most people just said, well, no, of course you don't have a jury right in those circumstances. That's a crazy argument to make. So I guess maybe a bit of advice, and maybe it's the same thing that Russ just said, is don't be put off by a prevailing view or it's always done that way or anything like that, because of course it's always done that way until it changes. And it's not done that way. So it's good to make the arguments.
Yeah, you do have to be somewhat careful, though. I mean, you certainly don't want a judge to think that you're defying precedent or not bringing it to their attention.
Right.
I think the way to do it is you mention the argument, you acknowledge that the precedent is against you, and but we don't agree with that precedent, and if and when we get to a level of court that's above where that precedent was set, whether it's en banc or a cert petition, then at least you have the freedom to give a full-throated explanation for why you think that precedent is wrong.
You both have been involved in some major cases recently about, I guess in general, like the constitutionality of the ALJs and the administrative proceedings, Lucia, Cochran, Jarkissi. I was wondering if you have any, is it all going to come down to Jarkissi? Is that going to decide everything? What's the likely fate of the administrative proceedings in the ALJ process as it exists right now?
Well, firstly, I've written about this, but the SEC effectively is not doing ALJ proceedings anymore. Once they kind of threw in the towel in Lucia back in 2018, they, for all practical purposes, stopped assigning cases to ALJs. So there's maybe a trickle of them, 2 or 3 a year at most. But I think Jarkissi will shine a lot of light on this and answer a lot of questions. It obviously depends on how the court rules and which issues it rules on. But I am fairly optimistic that at a minimum, the court is going to say, if an agency like the SEC is suing you for fraud and seeking penalties, that needs to go in an Article III court where you have a right to a jury trial, at a minimum. I think the removal protection issue in that case has effectively already been decided. If you read Justice Breyer's dissent in the Lucia case, or maybe it was a concurrence, I can't remember. It's in my view almost a foregone conclusion that the ALJs do have too much removal protection, and the only question is what's the proper remedy for that. And I think that's probably beyond the scope of today's discussion, but it's an interesting question that has confounded some people that are in the doing this type of litigation.
Yeah, I think every Supreme Court case, of course, spawns new potential arguments to make, new ideas for challenges to assert, and so we'll see how the Jarkissi ruling comes out and what those new arguments are. But I anticipate, follow-on APs, to circle back to one of our topics, may be impacted in some way by the Jarkissi case, depending on how it comes out.
Russ, what about all the cases that are already in the process? Is that the Hotel California situation that you've written about, where there are all these administrative proceedings and they just get stuck in there and nothing happens?
Well, the main location of the Hotel California was cleared out about a year ago. I think I mentioned this earlier. In the aftermath of the Supreme Court's decision in Cochran, the SEC dismissed 42 cases, including Michelle Cochran's case. Well, dismissed the underlying administrative proceedings, citing what they called a control deficiency. whereby the enforcement staff, through I'll assume it was neglect, was able to access the files of the adjudication staff. I've heard people refer to it. It's the equivalent of the U.S. Attorney's Office having access to the district court judge's memos between the judge and the law clerk. The SEC, I think it was in May or June last year, issued like an omnibus order basically dismissing almost, I think, every pending ALJ appeal before it. But until that time, it was taking the SEC years and years to decide those appeals. Now, that the second location of the Hotel California is a separate adjudicative appellate docket that the SEC has, which is when they review final sanctions orders by SROs like FINRA and the Public Company Accounting Oversight Board. Those cases, at least the commission sometimes decides them, but they're still very slow. Sometimes they take 4 or 5 years to decide them. They issue summary order after summary order, extending their time to issue the decision. And we filed a couple of lawsuits on that. One is still pending. That's my Hotel California analogy.
Another area that I'll be interested to see what happens is 102E professional bar administrative proceedings that normally on pre-Lucia, pre-Jarkissi would have been considered by ALJs. My understanding is those, by and large, have been stayed. The litigated 102Es have been stayed pending the outcome of Jarkissi. So if Russ is right, and I agree with him that the removal protections causes problems for the SEC ALJs, does that mean the commission itself will hear all of the 102E proceedings that are litigated? I don't know, but it'll be interesting to see how that shakes out.
Nick, you had actually flagged another Hotel California situation not too long ago, right? The billions of dollars are being held for distribution to investors, but the money never goes anywhere.
Yeah, that's a strange one. So the SEC obviously sues a lot of people. They get disgorgement, they collect disgorgement and penalties. That money sometimes goes just directly to the Treasury for general government use. Sometimes it goes to an investor protection fund. But there is this this large and growing, like to the tune of almost $4 billion amount that is held for distribution at Treasury. And I've asked knowledgeable people, what is that? It's grown substantially. If it's just a matter of, the lump of large settlements coming in from some particular enforcement initiative that has yet to be distributed, that's one thing that seems fairly innocuous. But if this is going to become the new Hotel California of funds that are neither released to the Treasury in general nor distributed to investors, I do think there needs to be some explanation for that. The size of that fund, it dwarfs the SEC's annual budget, so it's a big number.
Russ, that's 3 Hotel Californias. That sounds like a column to me.
I'm interested. I'm interested in maybe Nick and I could talk offline with it. You're not talking about though the Whistleblower Fund, are you? The
No.
fund they draw whistleblower awards out of.
Right. No, this is a separate. It's held at Treasury. They call it in their annual report held for distribution, which sounds good. That sounds like it's going to be distributed, but if you compare year to year, it keeps getting. Is that
like fair funds that they don't have the operational ability to get out to shareholders? Could
be. If that's the case, though, first of all, I think there should be more transparency by the SEC as to what that number. It's so big, it just cries out for an explanation. And if that's the case, it's growing every year. Something needs to be done with that. So if it's just a matter of it takes the SEC forever to set up a fair fund and identify investors and distribute the money, that's one thing. That doesn't appear to be the case, judging just from the continuous growth of the of the money sitting there at Treasury held for distribution. So we'll see.
I didn't think that we would have this much material, but we probably could go another hour. But you both have brought up the consolidated audit trail. That seems to be something that's a looming issue. I saw there was an op-ed by Bill Barr in the Wall Street Journal last week saying basically that this is going to take us down the road toward an Orwellian surveillance state. You guys have any opinions on that? And how is it different than basically the blue sheets plus go into FINRA or whatever it was to get the information on who's doing what trading?
I think the two main differences are just how vast this database is and the fact that it's freely available to not just the SEC, but a lot of other government agencies without any suspicion, no identified suspicious activity. People can, the information is there for the taking. Whereas, back when we did blue sheets back at the SEC, you had to at least have, I think what the courts have said, investigative curiosity about a specific transaction or person or something that you could articulate why you were looking at it. Here, and then you go through your paces and develop your evidence. Here, the evidence is there, it's evergreen, and it just leads to all manner of not just data breaches, which I think are inevitable at some point, but the occasional government agent who is going to think, show me the man, I'll find you the crime, basically. And with this vast database of every trade the person's ever made, that's just not the way government investigations are supposed to be run. It's supposed to be something comes to the government's attention that credibly suggests that there's some wrongdoing, and then you go and you find your evidence. You don't just pour through the evidence and try to find a crime. Those are the two main differences I see.
The data breach issue is a big one. I think I agree with Russ that the primary problem is the way this tool is being used and the issues raised in the NCLA suit. But the data breach issue is huge. I mean, the industry is alarmed at the prospect. They are compelled to provide the information to this database. If there's a data breach, the industry feels as though they're going to be the ones that get sued for being held responsible. So they've got all the obligation and none of the protection. So there's actually a separate lawsuit out there by the industry and raising some of those points.
I wanted to ask you quickly, Nick, about the Pulse chain case that you, I guess you're an amicus on.
Right.
Where as you described, the SEC is named as defendants 3 pieces of software, which seems novel to me. So what's going on in that case?
Yeah, so we actually represent a nonprofit foundation as the amicus, and the foundation represents the community of users of this digital asset, this blockchain technology. But yeah, the novel thing about the case is the SEC sued 3 pieces of software. It's a token, a blockchain, and a protocol deployed on the blockchain as defendants. And so there have been some analogs in other cases. OFAC brought a case against a so-called DAO. The CFTC had brought a case against another similar situation, but here it's a case against computer code. And we don't represent the parties, but this foundation that represents the community of users is concerned that if the SEC successfully get some kind of default judgment against these 3 computer code defendants, it will inhibit or at least severely chill their ability to use this network and to use this computer code for what they believe are First Amendment sort of expressive activities. So it's a weird case.
One last quick question I'll put out to both of you. Is there one important overreach issue that we haven't talked about so far that you kind of see looming on the horizon?
I'll go first. I've always thought that the biggest problem with administrative adjudication writ large is that it combines all three government powers, legislative, executive, and judicial, in the same body, which I think Madison called the very essence of tyranny or something like that, where the SEC writes the rules, it decides who's violated the rules, and then it adjudicates whether those violations have actually occurred and does the punishment. So that's what I'd say is the big picture issue.
And I guess in keeping with our ICANN mission about maximizing investor choice, I would say a significant challenge is the mindset that the best way to protect investors is to prohibit investments or to make the investments so burdensome to engage in. So an example of that is the accredited investor rule that prevents people with certain below certain net income and wealth thresholds from accessing certain private investments. So this investment protection through investor protection through investment prohibition mindset, I think, is a big thing for us to overcome.
Great. Well, if anybody out there who's watching wants to either volunteer or donate or team up with you guys, can they reach out to you directly?
That'd be great. Yes, please.
Yes, me too. Or go to nclalegal.org.
And we're at icanlaw.org.
Fantastic. All right. Well, that was really interesting. I really appreciate you guys making some time to talk. If the audience wants to just take a moment and click on the ratings button at the top and provide us with any feedback you may have, we'd really appreciate it. On behalf of Securities Docket, I just want to thank everybody for joining us, and particularly our guests, Russ and Nick. The webcast has been recorded. It'll be available shortly on Securities Docket as an archive. So thank you all, and I hope you'll join us again soon.